I think it was a mixture of luck and skill, and I did a lot of appellate work. There's if you go on like LinkedIn or something, there are people who are always talking about how do you find a niche? How do you sort of become, how do you become the person who does X, Y, and Z thing? And my answer is very boring and very old-fashioned, which is like you have to do a lot of it and then become good at it. Like I don't know a shortcut.
Welcome to the Represent More podcast, brought to you by We Are Them Media. I'm your host, Ryan Clarkson.
And I'm your co-host, Shireen Clarkson.
All right, we have a very special guest today, Shireen. Glenn Danis, Clarkson partner and appellate specialist with a thriving class and public interest practice as well, is in studio here today. He's our first guest of the podcast. Welcome, Glenn.
Thanks so much for having me. I'm really excited.
All right. Pardsy is in the house.
We've been talking about you, and now you're here in the flesh.
My ears were burning, and I am excited to be here and really honored to be the first guest on the podcast. So thank you.
Have you been on a podcast before?
I have. I've been on a couple, one for Daily Journal. They have a podcast series that's been going for a few years now, and then done a couple that were appellate oriented with different appellate lawyers that sort of have these podcasts where they get deep into the nerdery of all that is appellate work. So I think at least those like three, maybe.
Okay. All right. We might nerd out a little bit today, but we'll probably keep it cool too.
That's right.
Right, Shireen?
You always do. Yeah.
Yeah. Try to keep it cool. Before we jump into some nerddom, let's talk a little bit about what's going on in our lives. What's up with you, Glenn? What have you been up to?
Well, my family just got back from skiing. We were at Mammoth for a few days and had so much fun. There's really nothing that makes me appreciate California as much as being able to go skiing in just some of the most beautiful mountains where, it's 72 degrees and, at ground level, then we get up there and it's like 50s, beautiful, sun shining, and just ripped it up for like 3 days and got to see my kids who are like becoming real skiers. And so my daughter just turned 6 and she's like actually using poles for the first time and is like really doing okay. And my son, who is not the most athletic guy in the world, he has a lot of great traits, but athleticism isn't one of them, loves skiing. And this is the sport that he really thrives in. So my 14-year-old.
I would think that your daughter Margot would be a snowboarder based on kind of, her vibe.
I think it's still blossoming, her personality in the sport.
Yeah.
But she loves it, looks forward to it, didn't want to leave, wanted us to, said, can't we have 2 more days here? So it was great. That was really what I wanted. Someone, for her to look forward to it.
Man,
nice.
Spring break is such a nice time of the year, isn't it?
Yeah. We did the opposite. We went to the sun and the island life. We spent a little time in Hawaii.
Yeah.
Last week. So, and we had a good time.
Was there an egg hunt for the kids?
Of course there was an egg hunt.
There was.
Regardless.
Yeah, go ahead.
Go ahead, Ryan.
I'm so excited to talk about the egg hunt. No, you go ahead.
Yeah, no, we had a good time. It's like, yeah, Easter's a funny one because regardless of whether you celebrate Easter, everyone gets into the eggs. So we all got into it.
My daughter was wearing the ears on top of her helmet that they gave out on the slopes. They had like a bunny out there on the slope skiing. So.
Yeah.
Did they do a mountain egg hunt or anything like that?
They sure did.
That's great.
In the town, and they had something on the mountain as well. Margot was in ski school, so couldn't do it, but it looked awesome.
Yeah, that's fantastic. So we got up Easter morning, and I looked out the window and I saw all these kids gathering in nice pastel colors around this field in front of the beach. We're staying at the Fairmont in Wailea, Maui, which was beautiful. It was fantastic. And I see all these pastel colored eggs and I think, oh my gosh, the Easter egg hunt. It's Easter morning. So I wake up Ada Maris. And
out of a dead sleep, Ryan lost his mind when he saw the eggs. He looked out the window and he saw, the egg hunt happening. I don't know what happened to you, but you became very intense. Ada, wake up, and we have to get to the egg hunt.
FOMO.
FOMO. And that's Ryan's middle name, FOMO.
Yeah.
So,
is it?
Oh, yeah. So we did not
should
miss
drill,
the egg hunt.
We should drill into that a little more. Maybe not this episode. No, I wanted her. I know she enjoys that. She's always enjoyed it.
Yeah,
so I asked her if she wanted to do it. She's like, yeah, let's do it. So she threw on she got dressed in about 30 seconds. We ran down and they had handed out these nice, bags with the nice colors. And we were late to the thing. So I just kind of found a gap along the border of this field with all the eggs on it for her to step into. And then there was this grounds crew. And I asked him if they had any bags, and one of the guys held up a garbage bag, like a hefty garbage bag. And I said, Adia, what do you think? And she gave me no, we're not doing this. And so I ran to try to find like a proper bag, and they blew the whistle.
You lost your mind.
And I ran back, and she had taken the garbage bag from the grounds crew. And of course, it was like 50 times the capacity of what the other kids could have. So she really cleaned up. So
turned out
well. Yeah, it worked out well.
Yeah.
Anyway, spring break, a lot of fun. Good time to recharge the batteries. Anything else you wanted to touch on? Should we just jump into it a little bit?
Yeah, let's jump into it. Let's
do it.
You mentioned your family, and I know that you're a big family guy. I wanted to hear a little bit about, before we get into your work, and as someone I believe is one of the best appellate lawyers in the country, bar none, but also a true public interest trial court level strategist as well, who's working on some very important trial court level cases. I want to get into a little bit of the origin story, talk about, your family, your upbringing. Can you spend a little time, just touching on that?
Yeah, sure. So my dad played a huge role, I think, in how I got to be interested in what we do and what I do now. My dad was a brilliant lawyer, who, after he graduated from NYU Law School in the late 60s, he clerked for the Southern District of New York and was an assistant U.S. attorney under Robert Morgenthau in the 1970s with a lot of, really well-known lawyers. Michael Mukasey and Pierre Laval and all these folks were in his class with him. And really, just by showing what it's like to be a lawyer just made it very attractive. Something where I just remember growing up and hearing about him he worked on the Pentagon Papers case against Richard Nixon.
Wow.
In the Mid-1970s. He worked at some large law firms in New York. I learned the ups and the downs with what that might be like. But it was something where I just had this feeling that for someone that likes to get into it, that likes to really, sometimes likes to argue, likes to figure out why things are the way they are and not just sort of accept things at face value, it became something that was very interesting to me. I also became very interested in writing and reading, and was just a very avid reader as a kid. And loved to write. And my mom taught writing and English for a long time in high school, and then eventually at Columbia as an adjunct. And they just got me very interested in writing. So it was the thing that in college and I focused on. And when college was done and we were sort of figuring out what to do, I just kind of knew that it was going to be law school, but I didn't know what kind of lawyer I wanted to be. And, like a lot of lawyers, for folks who are not lawyers, that when we go to law school, there's kind of a career trajectory that's kind of pushed on us a little bit. And it's just kind of expected. Go to the biggest firm you can, do this and that. But I clerked for a judge, UW Clemon, right out of law school, who's in the Northern District of Alabama. He's one of the first black judges in the South. He was appointed by Jimmy Carter. Brilliant judge, just a great person. And we spent a lot of time together, and we would have cases, large environmental pollution cases that he was overseeing, prison reform cases. And I just remember the judge, when we would be talking about like motions, he would say something like, I'd be giving this large exposition about, the law in Alabama of, because some of these cases were governed by Alabama law about, a tort or property, obligations or
Sure.
what have you. And the judge would just say to me at the end of me giving this long law student spiel, he'd say, well, Glenn, was the plaintiff, was she impecunious? And I said, what is I think so. She lives in like a trailer, and I just assumed that she was, but he'd say, okay, we're going to deny that motion. And what I started to learn from the judge was that there are a lot of aspects of justice that are important beside just getting into the doctrine and viewing these things very narrowly. Legal doctrine, of course, is super important, but there are other things that are important. And when there are duties owed and someone's home burned down, the fact that they can't afford another one is something that makes us have to take a very close look at the case. So anyway, it was just something that really, really stuck with me.
All right. So we covered a lot there. So backing up a little bit, you grew up in New York City, right?
I grew up in New York City, and a very fun time to grow up there. Probably a time that was very worrisome for my parents because it was pretty relatively dangerous, but it was also incredibly fun, full of art and life and nightlife and all the things that make New York amazing.
Is that 90s New York?
This was like, I was in high school from 90 to 94, dating myself. And it was just sort of the tail end of sort of the Studio 54 era. That really went through the 80s and up until the early 90s. Yeah, it was great. And, got very into like the nightclub scene when I was in high school. And, if anyone who grows up in New York, you don't need rides to get anywhere because there's public transportation. So as 14, 15, 16-year-olds, we just sort of had the run of the city, and it was amazing.
That's awesome. I read the Mark Ronson memoir, and I think it came out in the last year or so, and it's probably just a soundtrack to your
Night People.
Yeah, Night People, exactly right.
Yeah, Mark went to collegiate and was 1 year ahead of me, and we sort of I would see him a lot at night, and when he started to DJ and got very interested in music, you could tell he was going to be amazing even as a high school kid. It was great.
What kind of music were you into in your teenage years?
Mid 90s, early 90s, it was punk and hip hop. So like if I was going to HMV and 86th Street to buy CDs, it would have been Sonic Youth, Fugazi, Biggie Smalls, and Mobb Deep.
Did you work as a teenager?
So I had my very first job. I was a CIT at a camp. Did not go great for me. I was not really on board with some of the rules for CITs. They didn't want us going out at night when all the counselors could go out. But I did do, I had a couple jobs, and I worked at one of the largest record stores in New York at Kim's on St. Mark's Place. And what I learned from that job was that every job is kind of hard, like there's no such thing as an easy job. And, just being at the most fun, cool record store, still had drudgery and stuff that I didn't want to do. And
what were they having you do in the record store that you didn't want to do?
Shrink wrapping. Learning how to use this shrink wrap machine, burning my hands on it several times, opening on a Sunday morning on St. Mark's Place when there's literally no one out, and I have to get up, and open the store, and I'm just like, who is buying, weird records and, whatever at 9 a.m. on a Sunday? Like no one, but you still have to be there. But there was a lot of fun too, and I got to meet, Richard Hell lived in the neighborhood. Kim Gordon, at the time, and Thurston Moore lived in the neighborhood. Jim Jarmusch lived in the neighborhood. Like it was just, it was very cool.
You know what?
Yeah.
I had one job that I don't believe was hard at all.
What was that?
I mean, and no disrespect to those who are in this industry, but I worked at a radio station for 2 years. It was so fun and so smooth, and I can't say there was anything I disliked about it in terms of the job.
That is
awesome.
This
was in college, right? At UCSB?
Yeah. And for a year after. I think it's an anomaly.
That is awesome.
Yeah.
What station and what kind of music?
Santa Barbara's Modern Rock, KJEE.
Wow, that's just rolled right off.
I tried to chime into the DJ voice, but
you got right back to it.
Yeah.
My first job that my first job was as a golf caddy in 7th grade, and I was a golf caddy until I was in 12th grade, until I went to college. Made great money, learned about the game.
Was it hard?
Learned,
Was
no,
was there anything hard about the job to
well,
glance?
other than lugging, golf clubs around, 18 holes, sometimes in the cold, wet conditions, up and down hills. But listen, I love being on the golf course. It was just a wonderful time and learning about the game, and then also learning from a lot of people who were very successful. At least for the place where I grew up standards. By any standards, really. A lot of successful people, business owners and lawyers and doctors and, financial people.
Yeah.
So
we just proved you wrong twice.
Yeah.
I don't know how that happened.
I think maybe I ended up with the tough high school jobs, but I will say there was a lot of fun in it too. So even with that, I should focus on the fact that I did get to meet a ton of cool people and build an amazing record collection. So
yeah, but the shrink wrap scars on the hands are still a constant reminder of
always there, the albatross.
So that's all super interesting. So then, you grow up in New York City. You end up going, where did you go to school for undergrad and for law school?
So growing up in New York, I went to Horace Mann from nursery through 12th grade. And then I went to Cornell for undergrad. I was in the School of Industrial Labor Relations, which really, pretty clearly got me more interested in what I do, at least part of what I do now, employment law. Because the School of Industrial Labor Relations is, focused on collective bargaining, labor unions, employment rights. All of that was like my major, basically. Yeah. So while other people I knew in college were learning and studying philosophy and literature and whatever, I was learning about collective bargaining process and the labor rights movement in America and watching videos about the multi-week Hormel plant strike in Ohio and really learning how important all of that is to who we are as Americans. And then I went to Emory in Atlanta for law school and had an amazing time, amazing city, and got interested in and knew about the Southeast, which is how I ended up clerking for a judge in Birmingham.
You were at Emory Law with our partner Tim Giordano as well, right?
Tim and I met. So Tim Giordano, brilliant guy, and funny and fun, and we became friends. I think the very beginning of law school. Everyone sort of finds their people, their little like sub tribes in law school, and Tim and I would just, we both smoked, so we would be, outside the library smoking cigarettes, and we liked to go out at night, and you could just tell he was very sharp, and we just had a similar sense of humor. And we studied together and we became friends and we did law review together. And when I was clerking in Birmingham, Tim was clerking for the 11th Circuit in Atlanta. And we stayed friends and we actually we went on a spring break trip together.
Where was that?
Quite infamous. So Tim picked me up and we drove to Panama City Beach, Florida.
Oh, yeah.
When we were at the ripe old age of 24, but we thought we were way too old to be at spring break, so we needed a cover story. So we told people that we were still an undergrad. So we were walking around being federal law clerks, telling people that we were still at FSU, carrying, trying to carry on conversations about all that. And probably not a great cover, but it worked okay.
Oh my gosh, that's so funny. Did you ever, have you ever used a cover before, Shireen?
I had a fake name for a while.
Really?
Yeah, I think most women do that in their 20s.
Yeah.
I think.
What was your fake name?
Lila.
I like it.
Thanks.
Yeah, you
thought it was
look
pretty.
like a Lila.
I thought I could pull it off.
I could believe that.
Thanks. Yeah. No, in your 20s as a woman, in college, sometimes you don't want to give all the real information about yourself. So I think most people tend to have a name.
Yeah.
I don't think I'm alone.
When I was in a boy band in my teenage years,
how does
my
this always come
was,
out? This information always comes out no matter what.
My nickname was
context.
Slick B. Slick and slippery.
Ryan.
How slippery will take a verbal ride with me.
Ryan.
I think we might need to bring that back.
We might
I like
have to
that.
bring it back. You know, it was before the internet era, so there's no digital footprint anywhere for one world.
Like right now, people are, on YouTube, going crazy.
Right.
You're not going to find it, everyone.
No,
So.
Yeah. No, and
give it up.
Tell us what does Slick B stand for?
It's obvious, isn't it?
It's not. What
It's
is
short for slick boy.
it? Which is not short for anything, right?
You literally don't even save a syllable. Anyway.
Slick B. We'll call you Slick B for the rest of the episode.
Okay, Lila.
Okay. Okay.
Did you guys use aliases on your spring break trip, you and Professor G?
That is a great. I'm almost sure that we did, although I can't remember them. But just the idea, and I think there are even pictures somewhere. So thankfully, not on the internet, but we can control who they get disseminated to, and maybe we'll make that a podcast, contest. You'll get to see the pictures of Tim and Glenn walking around with visors on the beach.
That's fun.
Panama City Beach. With a case of natural light.
Oh my gosh, that's too funny. All right, so you go to law school, you graduate, and you started off at big law like I did, but you were big law.
Yeah, so I got very, very lucky, and it was a good time for hiring. There were a lot of firms that were really ramping up, I think, due to like the first .com boom. And I got a job at Sherman and Sterling in New York, working in the litigation group, and it was really, there are for a lot of folks who aren't lawyers, you may not know, but at big firms have sort of they're a little bit infamous for working people extremely hard and having very long hours, or at least everyone knew that then. My experience at Sherman was really very positive. I sort of fell into working for this brilliant partner, Jeremy Epstein, who had been at the U.S. Attorney's Office in New York as well. He spoke and read Latin and ancient Greek. His walls were full of, he'd been a Fulbright scholar. His walls were full of, poems and just, sort of ephemera of someone who is very well-read and worldly. And he worked on, between him and a couple of other partners there, I got to work on some really very interesting antitrust work, and got substantive experience. I got to really write and argue some motions. And it was also there that I worked on my first appeals. And I worked on an appeal, pro bono appeal on behalf of a criminal defendant in the Second Circuit. We were on a panel that would take these kinds of things, or at least the partner was, and he sort of handed it off to me. And I worked on an appeal from a trial verdict. And both of those, I just fell in love with the writing and the figuring out of the law and going through the cases and sort of figuring out how they all fit together. And it was just, to me, it was like a cheat code to being a lawyer. It just like made sense. And I was like, I can't believe I'm getting paid for this. I can't believe I'm getting paid well for this. When a lot of my peers were, maybe doing doc review in the, some warehouse somewhere, or, Sherman and Sterling had a very international practice. So even the doc reviews tended to be in places that were kind of interesting. They'd be like in Kenya or Singapore or something, not
Right.
in a Ohio warehouse. But still, I got to do a lot of really interesting work.
Were you traveling internationally on junkets to review documents in these faraway places?
Yeah, the one of the partners at Sherman had a very active practice in the Foreign Corrupt Practices Act area, and those tend to be, just based on the statute, those are all around the world. So I worked on a case involving, I probably shouldn't say it, but a very large telecommunications company in Europe. And, the idea of that statute is to sort of make sure that people who want to do business in America can't be bribing local officials to do different things in other countries. So we had to set up with Kroll on the ground an entire protocol for how to, to audit this client and to make sure that they were doing everything right and weren't running afoul of the statute. But it was all taking place in like Tanzania and
Wow.
Kenya, and it was super interesting. I didn't get to go. A lot of the other associates did though.
Oh, okay. Gotcha.
So,
All right.
I had the less glamorous part of that. But, being part of the team that did that, it was very cool.
Oh, yeah.
Well, those were pre-digital days, right? So today, I don't think we would need to travel.
Exactly.
Right,
yeah, exactly. This was like the early 2000s. So it was like the very beginning of like having to collect all the employees' laptops, but not having, I don't think there was even Skype then. So there was no way to be on a video exchange or chat with anybody in real time. The only thing you could do would be the phone. And yeah, you just tended to go. And I think also there was just a distrust of doing things at a distance. It was like if you're doing it at a distance, people didn't take it very seriously. And for the most serious things, you had to be there. So, but that was also part of what was fun about that practice.
Yep.
Yeah. And, a lot of those big document reviews where you're, having to travel to different states or countries always seem to be located in some industrial place outside of a major city. There's nothing, it sounds very glamorous, but it really isn't. You're in some warehouse, digging through bankers' boxes that are half eaten by rats and other, varmints, right? It's really what it is.
I had my share of that too. And I worked on a case for Deloitte and Touche involving like agribusiness where I was just reading tens or dozens of the same contract for, different farming equipment and, grain. And, so it balanced out the interest in doing things that were, international, sort of espionage or, what have you.
Well, so I want to get into your work, but, to transition to that, I want to talk about, the fact that at some point you flipped to the other side of the V and you started representing plaintiffs against large corporations. And, talk a little bit about what compelled you to do that. Typically what I find with certainly everyone at our firm, it's something that we look for in a teammate, but also with just people generally interested in prosecuting cases, particularly public interest cases, is there's some connection to an underdog spirit, some desire to hold power to account. Talk about that a little bit. Is that something that you have? I know it's something that you have, within you, because we've talked a lot about it, but share a little bit about that.
Yeah, I think that there are probably two sides to that. I fell into doing plaintiff side work really a little bit by accident in the very beginning because I was at a very large firm in the mid to late 2000s that went under, and I was kind of looking around for what to do next. And rather than take the next big law position, I got, someone told me about this plaintiff's firm that was hiring, and I didn't really even know that there were such firms. Like I didn't know, I knew that there were like personal injury lawyers who would have hang out a shingle and maybe do cases on their own. But I didn't know that there were law firms full of like very sophisticated lawyers doing work that was highly sophisticated, that would, be the same level in terms of competence as the biggest, largest defense firms. I just had no idea that that was out there. When I found it, and went there, I was like, this is where I should have been from the beginning and probably would have been if I had known about it. And like how this idea of underdog, when I was in college, I worked for Mark Green. He was the sort of Ralph Nader of New York. New York City has a public advocate position, which is actually I think it's either the second or third highest city position behind mayor. And Mark is very well known in New York, and he was like a consumer advocate. And when I worked for him, I spent a summer when I was 19 going around the city and, doing kind of investigations about different products, about baby cribs and about this and that. And like, that really was interesting to me. Like, I loved the idea of kind of going undercover and making sure that these places were selling products that were safe and all this, and advocating for, safety in products. I mean, I think all of us, certainly for me, I'll speak for me, found very compelling the story about like the Ford Pinto litigation and all of that from the heyday of class actions. So all of it sort of came together, and my interest in that, my interest in pushing cases and not just responding and dodging, but actually being the one that, wants to sort of be moving the litigation forward. All of that came together. And, I think a huge part of it was also the people that I get to work with. I mean, that is like, who I spend my time with. And it just feels and is much more comfortable for me on the plaintiff side than on the defense side. On the defense side, I think like the kids today call it imposter syndrome or whatever, but it didn't really feel comfortable. Even though I liked a lot of people I worked with, it just didn't feel like it was maybe the most authentic version of how I want to practice.
Why do you think that you feel greater authenticity being on the plaintiff side? What is it that you connect to, whether it's in your background or your upbringing or just your kind of constitution?
I mean, I think a lot of it is just the incentives for how the business comes to us. Our clients on the plaintiff side tend to be regular people, and regular people are different than the CEO of, De Beers.
Right.
When I was at Sherman and Sterling, like one of our cases was representing, like a blood diamond company, and their entire litigation strategy was how do we stay out of the United States? If you're pitching for business from De Beers, they probably have a very specific idea of who they want as their lawyers in America.
Who are we going to hire to help wash the blood off our hands?
Yeah. And it like probably wasn't the guy that was, at the time, a young guy like me that was interested in like, listening to like Minor Threat or the Beastie Boys.
Right.
Like they wanted someone much more establishment, much more, safe and serious, very serious. And, I just, I like being in a wider cross section of people, the people. And look, to be fair, I think even in big law, there have been changes over the last 20 years that are just sort of cultural at the macro level where, there's a greater tolerance for people to sort of be themselves. But certainly in like early 2000s in corporate law, there was an idea of what you should be, and it was like what you should not be, and what was not going to be getting the best business. And I feel now that when I meet clients, I feel very comfortable with whoever they are. I think they sort of like seeing someone who's a little bit more colloquial and less formal. And, I have a lot of tattoos. I wear, sort of casual clothing a lot. I mean, I feel like it's easy for me to relate to our clients.
Yeah. It reminds me of our Clarkson tagline, which is "We are them." I mean, it's so true, right? We relate to the people we represent. And so it makes it that much easier to prosecute cases and advocate for them because we are them.
Yeah, we are consumers, we're investors, we're workers, we are patients, we're insureds. Some of us even, maybe survivors of abuse and other things.
Yeah.
So, yeah, I mean, having the ability to connect to the people we represent, I think puts us in a better position to be successful on their behalf, right?
Absolutely. And I also I just remembered one other thing that I think goes to your question about how I sort of got interested in all this. When I was in law school, I started studying about class actions for a large paper I was writing for the Law Review. And I read the congressional testimony of Elizabeth Cabraser, and it was just so powerful and so awesome. She was just, it was like her for anyone who doesn't know, she's a pioneer of class actions and, was in Congress in front of this, just all the senators and the congressmen and really just laying it down. And it was so compelling. And I just thought to myself, oh yeah, like this is what I want to do,
Full circle moment because we now co-counsel with Leif Cabraser on a number of cases. So that's pretty cool. You run the Clarkson's Appeals and Writs Department because you are one of the best appellate lawyers in the country. And I want to I want to hear a little bit about how that came to be.
Yeah, no, and thank you so much. That's like very kind, and it was something where I think it was a mixture of luck and skill, and I did a lot of appellate work. There's if you go on like LinkedIn or something, there are people who are always talking about how do you find a niche, how do you sort of become how do you become the person who does X, Y, and Z thing? And my answer is very boring and very old fashioned, which is like, you have to do a lot of it and then become good at it. Like, I don't know a shortcut. I suppose that there are people now who want to figure out different ways to go viral for this or that. But the way that I did it was to do a lot of appeals. And I worked at a firm. I was very lucky that they wanted to invest in and cared about the law and growing the law. And I worked on a ton of appeals and got a lot of arguments and got to go to court a lot. So at this point, I just had my 66th appellate argument about a month ago, and have probably written briefs for another 100 appeals or so. So I've been involved now with at least 200 appeals overall, and now many years in, we sort of have the ability to pick and choose which ones we want to work on. We know or have some sense of what we think is going to be more successful than something else. But yeah, I mean that's how it happened, and yeah.
It's amazing. 66 arguments at the appellate level is, I mean, I don't know many attorneys who can tout that. And among those are some very significant cases that you've worked on, and you've got some significant ones on the horizon. So I think many of these have arisen out of the employment context. You're kind of the go-to appellate lawyer for any case arising out of the employment context, I would say. But certainly in recent years, it appears that the breadth of your subject matter expertise has expanded greatly as well. So talk to us a little bit about some of your significant cases that you've worked on, just briefly, and what you have on the horizon that you're excited about.
Yeah. And that's 100% true. I mean, part of what is so great about our firm is that we have a very broad, coverage. I mean, we do the most important cases in a number of different areas, and of course that means that I get to work on the appeals for those, but also from outside the firm. But I would say that there was a case, Iskanian versus CLS Transportation, which went to the California Supreme Court in 2014. And this decision, the timing of it was fortuitous because it came after the United States Supreme Court had just really closed the doors on class actions. There was a case called Concepcion, which was a Justice Scalia decision from 2011, which really made it much more difficult using mandatory arbitration agreements for either companies that are in the consumer space or for employers. They could basically write themselves out of liability by including an arbitration. I don't like to call them agreements because they're not even really agreements.
Right.
They're just clauses that are inserted into the fine print of something you buy. And all of a sudden, your Seventh Amendment right to a jury trial is gone.
We should spend some time on that one episode, Shireen, just talking about the evolution of the FAA's, arbitration case law and the way that statute has been interpreted to be so expansive and all-encompassing.
Yeah.
Because it just feels right. I mean, we've gotten so far afield from what I think Congress initially intended for that statute to be. It's incredible.
And it's an area that I think that most people, unless you're a lawyer, but unless you're a lawyer specifically, you're a litigator and maybe even a litigator in the class action space or the employment space or something. Most people don't understand the amount of change and unfortunately the bad change
right.
that's happened using mandatory arbitration. So I had this case, Iskanian, which basically the California Supreme Court saw what was going on and cut back a big part of the U.S. Supreme Court's closing of the doors for California employment cases. And it was it became something that was people across the country took a lot of notice of.
Landmark
the defense bar,
decision.
it was a huge decision. And the defense bar, especially the Chamber of Commerce, tried 7 different times over the years to get the U.S. Supreme Court to take it up and reverse it. And ultimately, in 2022, there was a decision that cut back a small portion of it, but it's still the law in California for the most part. And that decision opened a lot of doors and sort of led to me to get a lot of other kinds of work and a lot more notoriety.
You've got some other big arguments on the horizon, the near horizon. Maybe pick one that you're particularly excited about and chat about it if you could.
Sure. I mean, the newest and most recent, the California Supreme Court granted review in our case against Twitter, which is a case involving consumer privacy. And basically, Twitter was using people's personal identifying information, saying that they were using it for 2-factor authentication, but in fact, were selling it and using it for targeted ads.
Wow.
And the FTC figured this out and hit them with a very large penalty, 9-figure penalty. And then there was a private class action that went after Twitter for other kinds of damages, not civil penalties, but rather other kinds of damages for the same conduct. And the California Court of Appeal said, well, part of why we're going to affirm a dismissal, basically say that there's no case here, is because there's no standing. And there's no standing. That's a sort of legal term that basically means that, folks didn't lose anything. They're not out any money. What does it cost? Their PII, their personal identifying information. That's not money and that's not property. And that just seemed absolutely and clearly wrong to us and is old-fashioned and is entirely out of step with, the fact that there is a huge data market. I mean, anyone, most people now are aware of the fact that our information is a huge source of revenue for companies.
So what kind of information was Twitter using, was selling, that was being gathered under the false pretense of 2-factor authentication? I imagine, mobile numbers, email addresses, other personal identifying.
Birth dates,
wow.
People's, interests and habits. All of that was being packaged up and sold as ways to sell more products to people because that's how Twitter makes money.
I mean, listen, in the digital economy, isn't it true that data like that it's like oil?
Exactly. And in this case, the California Supreme Court granted review 9 days after the briefing closed, which is very fast because I think they see that this is very important. And hopefully the California Supreme Court is going to follow some of the federal courts that have said, hey, this is money or property within the meaning of the statute because the person who parts with their information and no longer has exclusive control over it is giving up a lot of the bundle of sticks that make up property. They're giving up a lot of what makes it personal property.
Do we have a date for oral argument on that yet?
So I would guess that argument's going to be in the fall.
Okay.
We're just starting to to put together briefing. And there's going to be a lot of interest from what's called amici, from people from different the Electronic Frontier Foundation and different nonprofit groups and professors. A lot of folks are very interested in this issue because it really touches a lot of different practice areas and a lot of interest groups and the stuff that they advocate for, especially privacy-oriented groups.
Shireen and I were talking about the amicus strategy and what that means and how that works. We were talking about how our firm represented Cory Booker in a recent amicus brief filing with the Supreme Court of the United States. Do you want to get into that a little bit, Shireen?
Well, we were hoping to hear from Glenn on that. Yeah, you maybe explain what an amicus brief is and what we intended to do with the one on Cory Booker's behalf.
Absolutely. There's in all of these appeals that go on throughout the country and at the U.S. Supreme Court, but elsewhere as well, people, obviously the briefing is submitted by the parties, by the two sides of the dispute. But for a lot of important issues that are important to other groups, like let's say the ACLU or different colleges or other groups, they will want to weigh in and say, hey, court, there's some stuff that's not quote unquote in the record,
Right.
but you should know about it because it's going to impact the decision. A very famous case of that was the Balda study from 1988, where a number of Columbia professors helped the United States Supreme Court understand the death penalty by giving them access to academic research about how the death penalty had been carried out in a way that was unfair and biased against certain groups in society. And that kind of thing is always done by amici or by the different friends of the court.
Right. So you've got amicus curiae, which I think translates to, this would be good for your former mentor Epstein, friend of the court, and
Not to be confused
Not
with
that Epstein. This is a much better
Jeremy
Epstein.
Epstein.
A much
You said
better
right?
Epstein.
Jeremy Epstein.
Okay.
Thank you for the
I
clarification.
mean, I think it had to
Shireen.
be said. Yeah.
Right. Just to, so friend of the court. So these are non-parties that want to weigh in so that the courts have additional context. It could be, something, a technical argument or an academic aspect of it. There could be, experts may want to weigh in on the matter, right? It could be some non-party organization that wants to talk about the practical realities of what the decision could mean for, ordinary people, right?
Exactly. And so to your point about, us being asked by Senator Booker for the second time to author an amicus brief, this is one where, Monsanto is trying to, in a case that's in front of the Supreme Court right now, is trying to cram through the courts what it was unable to cram through Congress regarding basically writing themselves out of liability for carcinogens in their products, in their particularly in their Roundup product.
Right.
And Senator Booker is uniquely positioned to be able to speak to some of those efforts at changing the law in Congress that have failed. And that have failed for a reason, to let the United States Supreme Court know, hey, you should understand that, when it comes to the statute, this is all context that's very important when you're trying to figure out, like, what are the boundaries for this federal statute that would apply and maybe preempt state tort laws that these folks who were injured by Roundup are trying to sue under.
Yeah, you've got thousands of these lawsuits arising out of state law violations, which are pinning liability on Monsanto because they are failing to warn of the risks of cancer in their Roundup products. So people exposed over years or decades to Roundup, not knowing that it presented a cancer risk, are developing these horrible cancers or have died from it. And so their family members are taking on Monsanto in their name. And Monsanto is saying, let's just totally shield ourselves from liability entirely from all of these lawsuits for harms we've committed, that juries have concluded they're guilty of, right? They're liable for, by simply asking the courts to give them immunity that the state legislatures that the federal legislature repeatedly has failed to give them.
Is that because the federal statute that governs pesticides and other things, FIFRA,
Mm-hmm.
right? Is that because that statute would otherwise not would allow Monsanto to be free from liability, or is it just one hurdle that they're trying to avoid? In other words, the preemption.
Yeah, I mean, I think the idea is that if the product is allowed to be on the market, then it per se is consistent with FIFRA, this federal statute involving pesticides and rodenticide and whatever, and therefore there's no room for the states to do anything. States, are fully excluded from what's called the field of this entire area of conduct. And it's a very common argument made in the world of toxic torts and sort of, poisons, essentially. And this is the tobacco companies argued this back in the day. I mean, this is a old hat to the world of torts. And they tried to get themselves written into the statute in a particular way that made it clear that it would allow them essentially to continue selling and not warning of cancer risks, to make it even clearer so that it didn't have to be implied, but it was actually in the statute. And Congress has said no, 6 times, and it made it clear in prior, discussion in Congress and the United States Supreme Court as well, saying this is an area where states have the right to regulate. Anything other than the very small bit that's really expressly governed by the federal statute, the rest of it is for the states.
So the appellate work that you're doing is very exciting. We've talked about some amicus briefing, what's happening with some of your, cases on the horizon. But you also have a thriving trial court level practice. And among the cases you're prosecuting are a very significant and impactful and important line of cases involving healthcare and artificial intelligence. I want to get into that a little bit and talk about some of those cases.
Yeah. Can you tell us a little bit? So we've got a group of cases, class action cases, separate ones that we've filed against health insurance companies for what we're calling their unlawful use of artificial intelligence or algorithms to evaluate claims, right? So can you tell us sort of in plain English what the gist of these cases are?
Yeah, sure. So, the healthcare companies are constantly trying to figure out ways to make more money. Medicare is one area where the healthcare companies make a huge amount of money. And just to put that into perspective, United, the largest healthcare insurer and one of the defendants in one of our cases, each year is now making about $149 billion from its Medicare Advantage business alone. And Medicare Advantage is basically them saying to the government, hey, we'll administer this for you, this government program of Medicare. We'll make it better and easier to get and broader in coverage and better service and all these bells and whistles. We'll rely on us and we'll deal with the older folks, 65 and over who are relying on this and who buy it to get better coverage in their later years. And what turns out they have done is they said, at scale, how can we save a lot of money? In any given case, of course, we can deny something or, prolong it or shorten it or what have you. But how can we do this to affect coverage for tons of people all at once in a way that looks like it's fair or objective? And they figured out that they could do that through a separate company that they bought that developed an algorithm. To the extent that it's AI, we're still figuring out, but it's, whether it's learning on its own or whether it's just executing, it is a, computer-based decisional system where humans get to dictate essentially how much they want it to be allowing for coverage of claims and then program it and then let it run and say, here, this thing is really making the decisions. And it's, it's infallible. I mean, who could doubt this?
So the way that it works is you've got, let's just talk about the incentive model for these companies, right? The way that UnitedHealthcare, Humana, others make their money is by earning as much income as possible from insurance premium payments that their customers pay and minimizing the amount of health care that they are contractually and legally required to provide those customers. And the delta, more or less, is their profit. And you're saying that number has been roughly $150 billion per year just on the Medicare business alone, Medicare Advantage business alone, for a number of years running. Did I understand that right?
That's 100% right. And United and Humana basically use the same product in order to try not to try to minimize the coverage that they're providing and allowing them to make more money. And this is I should add, this is for Medicare Advantage patients, and it's for the most expensive kinds of care. It's for long-term care that follows, some sort of traumatic injury or anything where folks are going to be in a skilled nursing facility or a long-term care facility or a rehab facility. Anything that's long-term care, very expensive. And if you can shave some days off of the amount of time that the thousands, tens of thousands, millions of people are going to be getting, and make it so that it's very difficult to appeal, and make it so that folks will just say, well, I thought I was really going to be due 3 weeks in this facility, but they're kicking me out after 16 days. I mean, who's going to, am I really at 88 years old and, dealing with immediate health problems? Am I really going to spend all of my time trying to fight this at multiple levels of an appeal? Of course not. People will just go out of their pocket and pay it. And it ends up being ruinous to many people, to say nothing of what will happen to their health if they're, let go or really forced to leave prematurely.
It's so sick what these companies are doing. They are supposed to be sharing, their services, providing these services, in order to improve public health and their customers' health. And in fact, they're just, doing the opposite. They're shortchanging health. They're putting these people in very difficult circumstances where they have to forego care entirely, or they have to deplete their savings in order to obtain what they are contractually and legally entitled to from these companies. And I think it's completely sick.
Yeah. Okay, so just to be clear what we're talking about, what the AI is, and I know it's sort of a black box. We don't know exactly what this algorithm or artificial intelligence, how it works exactly. But as compared to the traditional way that insurance companies were or are supposed to be looking at claims, what exactly is the algorithm doing? Is there any human, doctor kind of intervention here?
Yeah, no, that's a great question. And look, the people who run this are not dummies, and they understand how to try and give it the patina of something that is fair or just. So what we understand is that they have used historical data and have tried to use that to figure out and to predict what the amount of care someone is going to need, and then to continually sort of ratchet that at the lowest end of a spectrum, and then to say, okay, we're gonna have this AI or algorithmic tool calibrated in that way, and then the doctors, the folks that are the professionals, the humans at the company, are going to be both with a carrot and a stick, are going to be forced in different ways or coerced to follow that output. So we're going to sort of make sure the output is at the lowest end of the range, or maybe even below that a little bit, and then we're going to make sure that no one can deviate from it. But then give us the cover of being able to say someone signed off on it. So how do you mean? How do you mean that this is an algorithm making the decision? Of course it's not. And this has been United's, argument in court against us from the beginning. You're just wrong. Humans are making these decisions. Of course, we know that that's not really true. It's humans who have their livelihood and their own jobs on the line and are being told you're going to be fired, or you're going to be demoted, or we have other ways of controlling you if you deviate from this expected length of stay, value that the AI spat out.
Yeah. This is, I find these cases to be so important, and, just digging into some of the stories of our clients, the Jackie Martins and others, they are so sad and frustrating. I wonder how it's possible that we've just totally lost the human dignity from the healthcare process, and we've done it at scale, and it's really a shame.
Well, look, I will say that the bright spot in these cases has been that even across the political spectrum, we're seeing outrage from folks. The judge in our Humana case, is a great example of someone who was appointed by President Trump, and immediately at our first really substantive hearing, let it be known that she was incredibly concerned about the allegations in the complaint. So this is one of the very few areas today where there is not a huge polarization, but really, I think there's outrage just across the board, which is heartening to us.
Yeah, there's less consensus about whether the Earth is flat than whether this is wrong.
Yeah, I mean, it's like almost like one of the only areas we're going to find everyone in agreeing is that this kind of behavior is just evil and needs to be stopped.
And you know why? Because we all have parents and grandparents, and we ourselves are all going to get older and be in this situation one day. And, and so we see this not only as blank anonymous faces and names and people, but I think we see our family members. I think we see ourselves, and it I think centers it and humanizes it even more than maybe most cases do.
Yeah, absolutely.
Yeah. So how do people know if their health insurance is using an AI, right? And what can they do about it, right?
I mean, there's really there's very little way of being able to really know. If you're out there and you have, a Blue Cross plan or an Aetna plan or some plan from a smaller kind of regional insurer, it's very difficult. I mean, we're fortunate to have some really stand-up whistleblowers and great journalism from amazing, brave, and very careful journalists that uncovered some of these stories, and then got it to a point of where it could go to Congress, and Congress could start asking some important questions. But I mean, for most people, you would never know. You'd get an explanation of benefits, and in the lower right-hand corner, there might be a subscript with a jumble of letters or symbols. And that would be the thing that internally would let you know that this was something that was derived from an AI or an algorithm. It's not something a normal person would ever know.
Right. And so, but we know that UnitedHealthcare is using it in some manner. We know that Cigna is using it. We know that
Humana.
Do we think that, is this the new wave? Are all these insurance companies going to be using AIs or algorithms?
I think the answer is absolutely yes. I mean, I since starting these cases, I've started to follow some of the industry newsletters and reading a bit about what's going on in the industry. And overwhelmingly, there's a huge amount of pressure and kind of trend towards using AI in all sorts of areas. And, we say this all the time. We're not against AI across the board. There are ways in which AI can be very helpful for repetitive kinds of tasks. But for making coverage decisions, that's a huge problem.
Right.
And that's the area where we have a huge bone to pick with the industry.
I mean, they rolled this technology out 2 years ago, or in many cases, more than 2 years ago. I mean, it just wasn't and isn't ready for prime time when it comes to life and death healthcare decisions. Even now, even with all the advances that we've seen from artificial intelligence tools, even now, I mean, would you, we've seen the catastrophic consequences of utilizing chatbots like ChatGPT or some of these other chatbots for therapy and for, life coaching, and just what that's done to, it's led to teenage suicide and all kinds of depression and loneliness and self-harm and all kinds of things that, are so negative, but predictably negative, that, we just need to make sure if we're going to do this, we need to do it with guardrails. And that was not done here.
That's right. And now, there are certain states like California that are stepping in, certainly in the healthcare space, where there is a specific statute in California now that requires that a healthcare provider, a human, be the one making the decision. But of course, where the rubber is going to meet the road is what does it mean to have the human? Is it simply signing off on something that was decided essentially by a computer, or is it something more substantive than that? Which of course we think it's the latter.
Right.
But that's what we're litigating, and that's a lot like our case against Cigna.
What's the current status of the cases? If you could just touch on that briefly.
Yeah. So each of the three big cases that we have gotten through what's called motions to dismiss. These early attempts based just on the law to get rid of the cases. And I should say that it would have been very easy for any of these three judges in these three federal cases to get rid of the case based on preemption, because preemption for Medicare is quite broad. Yet all three cases, many of our claims got through and are now being litigated, and we're in discovery and fighting very hard. And, I would say that United especially has taken an extremely kind of transigent posture in litigation and is making us fight them on every single thing. And eventually we just got the court to force them to, compel them to produce documents and answers to a lot of our what's called discovery, or questions to them. And we're going to be very soon, in the next 2 weeks, getting a huge amount of documents that should give us a much fuller picture of what's going on.
It's an exciting time. It'll give us an opportunity to pry open the black boxes of these algorithms and artificial intelligence tools, and see what's under the hood, so we can identify just how faulty and these systems actually were. So that's great. That's exciting. Right?
I think, and I want to understand or clarify what it is that we're seeking, right? Because we want them to stop using the algorithms or the AI in unlawful ways. I think if the algorithms were used in a way that efficiently approved claims and got people their benefits that they are paying for under their insurance policies, that would be a lawful and efficient way to use these algorithms. We want them to stop using it in such a way where there's no doctors looking at anything and they're just denying claims, outright. Is there anything else? That's one of our objectives, right? And is there anything else we're seeking out of these lawsuits?
Yeah, I mean, I think we're also seeking a claim reprocessing, which is going to be basically that folks get a fair shot at the claims that had been denied or, were subject to really de facto decision by the algorithm or the AI or whatever. That's going to be a huge part of it. So changes going forward, paying, and giving people a fair assessment of their claims looking backwards. And hopefully making them whole also for other costs of their time and their lives of pursuing these these appeals that really shouldn't be, where our grandparents and great grandparents are spending their last years arguing in front of an administrative law judge about an algorithm. Really, they should have just been able to spend that time relaxing or with their family, and we want to figure out ways to get them paid for that.
Well, I'm really encouraged by all of the hard work the team is doing, led by you, on these cases. And something you said about reminds me of just how I think behind the cases each of the judges are here, because I often think about. Let me back up for a second. When we think about the cases that we find to be most impactful and most worthy of litigating in formal litigation, which is expensive and requires thousands of attorney hours, some cases millions of dollars to invest in terms of expert work and discovery work, et cetera, we think about liability being strong. We think about damages being strong. But the third piece of the equation that's really important, and I think that a lot of plaintiff firms totally ignore, is outrage factor. And what I mean by that is is this important? Is this case going to hook the judge and the judge's staff? Will a court want to invest its judicial resources into the case because the court finds it to be an important issue. And, something that you just talked about on the preemption side, right? That, there were arguments available that, that maybe, could have hooked a judge to grant a motion to dismiss on preemption grounds. But the judges didn't do that here because they found our arguments more powerful and more persuasive. That's true of a lot of, different procedural motions and substantive motions. It's true on motions to dismiss. It's true on motions for class certification. It's true on motions for summary judgment. It's true on motions in limine. It's true on discovery motions. I mean, a lot of times these things are coin flips because there's law supporting both sides of the argument. And so having the moral high ground, having an outrage factor that might be enough to tip the scale in favor of our clients and our case, I think is super important. And I feel like we have that here.
Yeah, absolutely. I mean, this is, for people who don't know about this, there are people out there who think that, they hear about plaintiffs' lawyers and they think about, the 11-inch subway sub or whatever. This is pretty clear evidence that a lot of what we do, or at least what we do, is going to be stuff that really matters quite a bit. And we, our time is limited. I mean, we don't want to spend our time on highly technical things that really don't matter much in the world. But we want to spend time on these cases because it really matters quite a bit.
Shireen knows I'm a big NBA fan, and my favorite player is Steph Curry of the Golden State Warriors. Shout out. You grew up he's listening. But he wears number 30. And so I think about the cases we want to bring in formal litigation as Steph Curry 30 cases.
That makes a lot of sense.
10 out of 10 on liability, 10 out of 10 on damages, 10 out of 10 on outrage factor.
Mm-hmm. That's how I thought about it too.
Yeah.
The Steph Curry 30.
Yeah.
Yeah.
Cool. Good. I want to ask one question, then we'll get into Rose Butterthorn, I think, wrap things up. But what are you most excited as you kind of look ahead in the months and the year ahead? What are you particularly excited about?
Yeah, so I'm going to have a California Supreme Court argument in a case called Leaper versus Shipped, which is very interesting and really is going to be very important for employment litigators in California. It involves the Private Attorney General's Act statute, PAGA, which is, for most lawyers know what it is at this point because it's a center of a lot of litigation. And that should be very exciting. And whether there's going to be a seventh justice on the California Supreme Court for that argument. My last argument in front of this court, it was in November. The seventh justice, Justice Jenkins, had just left the court. So now there was what's called a pro tem judge. Someone from a different court was sitting for a certain amount of time. Whether there's going to be a seventh justice there or not, for me, is very exciting. And it's just always very exciting to be in the California Supreme Court. So that's going to be, that argument should be in, I don't know, July or August.
Where will they likely draw that seventh justice from?
Well, that's a good question. I mean, our governor has really made the quality of the California Supreme Court justices and all of the appellate justices in California very high. I mean, there's almost no room now between what it's, the qualifications and the credentials and all of that for our judges versus federal appellate judges, which is to say that these are the very smartest, most qualified people. So I would expect it's going to be someone from, probably from the Court of Appeal. But it could very well be someone from academia, or it could be someone coming from the Department of Justice or something like that.
Interesting. All right, we'll keep our eyes on that. Shall we? I
have a final question.
Oh, you do? Before we go to Rose Butterthorn?
Yeah, I have my last question.
All right, what do you got?
This is something I've always kind of been curious about with Glenn, and I don't know the answer to this. So I'm gonna ask it.
Shoot, this is your chance.
This is my
now.
big chance. Yeah. So, okay, Glenn, you're obviously a very well established expert in the appellate world. You know, the appellate cases that you work on impact not only the single case that you're appealing, but or on the other side of, but they have broad impact, right? And so I imagine that's really exciting. But you're also at our firm on some of the most important trial court cases and biggest and broad reaching. And so I'm curious what you find more, I don't know if there's a clear answer, but what you're more excited about, or what your, where your passion lies. You answer it, however you want. There may not be.
Yeah. I mean, I think that what's exciting about work at the trial and district court level for me is there's an immediacy to it that we just don't have in appeals. Appeals are very slow, and there is no immediate gratification. Everything is just a very small piece in a mosaic of law, and you're sort of hoping, and it sort of all leads up to one point where there's either a yay or nay or, some other kind of disposition.
Mm-hmm.
With these trial court cases, there's an immediacy. We can find a fact out that changes the entire complexion of everything, like now, today.
Yeah.
And it's very exciting. I mean, it's a lot closer to like what people think of when they watch TV or something. I mean, it's like you can learn in this big dump of documents that there's something there that really changes everything, and that gives you a real new insight. And that's very exciting. And I'd sort of forgotten about that for long stretches where I was doing, almost all appellate work. So, I will say, though, that the thing I like about appellate is collegiality. And like very rarely is there anything to argue about with the other side, because everything is just on the papers. There's no advantages to be had from not being collegial with the other side. You're not going to game them by not giving an extension or whatever. People are kind of friendly. I usually leave the courtroom and chat with the other side, with the lawyer on the other side. And I genuinely will mean, you did a great job, and we'll sort of give each other some. And the trial and district court tends not to be like that. Just because there's a lot more wrangling, and there's either a perception of or actually some advantages to be had for being a jerk. And people will tend to sometimes be like that.
Yeah.
And I don't miss that. And that's the part where I'll say, man, give me sort of the less, the less stressful, the less, less animosity world of appellate work. But I like having both, because I like having both sides of, the coin kind of represented. It's a lot of fun.
Yeah. Yeah. Those are interesting points. The factual side of the trial court work, right? You're always investigating the facts. You're learning in discovery. There may be surprises, right? Whereas in the appellate world, you're not really dealing with too many surprises.
No surprises at all. And I will say, like, another thing about the trial courts is that when you're in the state trial courts, sometimes there are judges who are just work too hard, and they have too many cases, and they just don't give really. My dad used to make jokes about his first time in state court after many years being a federal prosecutor. And he said that the judge was like talking off to the side with some court staff. So he paused to give the judge an opportunity to finish and get back. And the judge looked at him and said, what are you doing? Like, move it along. Come on. You don't need to wait for me. And I was like, oh, okay. And that spirit kind of informs some of the state trial courts, not all. And I certainly don't mean to think that's their fault. They have to deal with a general docket of a zillion cases. But, it's nice to have judges who spend weeks reading the briefs, and you tend to get that more in the appellate courts.
Yeah.
Yeah. It just is unfortunate that the courts tend to be underfunded, understaffed, and it's always where politicians want to make the first cuts for some reason. But yet, it's the most important part of a functioning democracy is to have functioning courts, so,
which we've been seeing a lot of lately.
Sure,
some of our courts have really been standing up for the rule of law, and it's very important.
Absolutely, yeah. We could probably spend a whole episode on that alone. Maybe a nice cliffhanger. Shall we get into Rose Butter Thorn?
Yeah, let's do it.
Do you want to explain what we're doing here?
Yep, Rose Butter Thorn. So Glenn hasn't done this with us yet, but we like to end our episodes with rosebud or thorn. So either one thing that was a positive in which is your rose over the last, say week or two, one thorn that you may have experienced that you may want to share and get off your chest, or a bud. So something that came about that you learned from. So we like to pick one of those things and highlight them at the end of our episodes.
Do you have one ready?
You know what? I was thinking about it before this episode, and I thought, maybe something will come about during the episode, and sure enough, it has, which is...
Oh, really?
Yeah.
All right, get into it.
My bud of the week. My week was otherwise looking to be a little bit...
Bud of the week, I think they sell at
Did I say
High
bud?
Times just down the street.
Bud of the week.
Right?
There's a dispensary, right?
Actually, yeah. No, my week was looking a little bit, we just came back from vacation, and I have a lot of work ahead of me. I told you a stack of digital memos that I need to read through, and a bunch of stuff.
They had CDs. What are they?
Digital memos.
CD-ROMs?
And our episodes are, it's usually me and Ryan just chatting away. And this week, having Glenn on is my bud.
Oh,
this is my bud.
it's
Seriously,
very nice.
Thank you.
This was a cool experience, and I learned a little bit more about you than I already knew. And Glenn is my bud. No, my rose. My rose.
Your pal.
Thank you.
Your rose?
I meant my rose.
Yeah.
I've been saying
You've
bud this
been
wole
saying
time.
bud.
No, I didn't learn anything from you. No, I'm
But
just kidding.
no. But
It was sort of both.
Really?
No, it was
I
sort
learned
of
a lot
both.
today.
A bit of rose.
Yeah,
Bit of rose.
exactly.
Yeah. There you go.
He's your bud and your rose.
A
Rosebud.
there
you go. Your
rosebud.
My rose.
I'll go and I want to. Gosh, I'm still in Hawaii mode a little bit.
Okay.
So my rose is, and we kind of started our conversation today about family and the importance of spending time and kind of recharging the batteries. Spring break was an opportunity for us to do that. I had a wonderful time in Maui with the family, spending time with Adia in the pool, in the ocean, at the beach. The hike to the waterfall was super fun. Maui with the family, spring break, that's my rose.
Yeah, Glenn, you beat Hawaii for my rose.
That's pretty good. That is pretty
I
good.
could have given that answer.
That is pretty
Right.
good.
Yeah. No, that's good, Ryan.
Actually, I'm going to change mine to Glenn as well.
Yeah. Okay, so mine will be, what am I thinking about? I'm thinking about something I'm really looking forward to. So in a few weeks, I'm going to go to London to speak to a lot of our colleagues overseas about, American hour practice and American class action practice, and specifically the healthcare AI cases, but other stuff. And I always find that those opportunities to be really exciting and sort of invigorating, because in a lot of ways our European friends are sort of newer to the class action world, and we get to impart some wisdom or experience or whatever, which is very exciting. So yeah, we're going to be doing that in London, which I'm looking forward to very much. And then I'm spending a day or two with a friend of mine from college in Dublin. So that's a rose. I'm really looking forward to it.
That's good stuff.
That will be fun for sure. And those conferences, especially the ones overseas, and London is a wonderful place. What a great world-class city, right? Should be a lot of fun. So, all right, good luck. And Glenn, thanks a lot for being our first guest on the Represent More podcast, and really appreciate the conversation and learning so much about you, your work, and thank you.
Thanks so much for having me. It was a pleasure.
All right. I'm going to read us out. Represent More is a production of We Are Them Media, featuring me, Ryan Clarkson, and my co-host, Shireen Clarkson. Represent More is produced and edited by Marketing for Justice and Q Michelli, and recorded live here at our studio in beautiful Malibu, California. Glorious sunny day today. Be sure to subscribe to Represent More whenever you get your podcasts, and find us on Substack at representmore.substack.com. Thanks for listening, and we'll see you next time.